Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled, The Same Old Lie. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, I would like for you all to hit that like button. And also, if you're new to my channel, hit that subscribe button. And also, hit that notification bell so you all can be notified as I'm dropping these power videos. So without further ado, let's get to it. Okay, guys, so I titled this video, The Same Old Lie, because that's exactly what's going around, guys. It's the same old lie. These men will come on the internet and simply lie with a straight face, guys. Like, come on the internet and just tell a blank out lie, making people believe that they are winning in these federal courts. So let's listen to this video real quick so we can hear, the lies that's going around. So if you out here, right, and you're looking for real help with child support, beware what you guys are listening to. Please, man, I cannot stress this enough. When I was coming up and I was fighting child support, there was no Yah is Magnified to put the truth out there like that. So I became that. So now let's listen to this guy's testimony and let's hear what he have to say. Let's go there.
All child support is a Ponzi scheme.
Was you on child support?
I was on child support, and I took my case to district. I took my case to appeals, and I also took my case to the United States Supreme Court, which is the highest court. And my case was dismissed. And anytime you take your case to the 9 justices, they're going to make sure that your case disappeared because they don't want anybody to get a blueprint of how you did this. All child support is a Ponzi.
So you guys heard it for yourself. The brother said that he took it to the district court, U.S. District Court. He lost. So he appealed it to the U.S. Courts of Appeals and lost there. But then he took it up to the U.S. Supreme Court and he actually won. He said they dismissed the case against them. And once you win in the district court, they're going to make the case disappear, right? Right, that's exactly what he said. As a matter of fact, let's hear him one more time, guys. Just so you all can see it. Let's hear it one more time.
All child support is a Ponzi scheme.
Was you on child support?
I was on child support, and I took my case to district. I took my case to appeals, and I also took my case to the United States Supreme Court, which is the highest court. And my case was dismissed. And anytime you take your case to the 9 justices, they're going to make sure that your case disappeared because they don't want anybody to get a blueprint of how you did this. All child support is a Ponzi scheme.
Okay, so again, you guys heard it for the second time. I let him testify against himself twice, guys. But look at his name. Remember his name. His name is Paul Lamar Hunter. Okay, so Mr. Hunter claimed that what? That he petitioned the U.S. District Court and he admitted that he lost. He also admitted that he went to the Court of Appeals and he also lost there. But he also stated that he went to the U.S. Supreme Court and the 9 justices ruled in his favor, dismissing his case. And after they dismissed his case, that the case is no longer available for us to find because they don't want us to find his case so we can learn what he did in his case to get off of child support. Those are his own words, right? Right. So if that's the case, then how come I have his court documents? According to him, we shouldn't be able to find these court documents because he won his case, which is a complete lie, guys. Okay? These men come on here lying, playing on people's hearts, trying to get people to believe something when it's not true. How many of these cats do I have to continue to expose of they all saying and doing the same thing? It's the same old lie, guys. To further prove that, first we're going to go over his Court of Appeals order when the court denied his petition in the Court of Appeals because he already lost in the district court, like I was telling you guys. So now we're going to go over his appeals court case order so we can see why he lost in the appeals court. And then after that, we're going to go over the order issued by the Supreme Court just to further prove to you guys that these guys are all scam artists. These guys haven't won a thing. They all telling the same old lie. To further prove this, let's get to it. Okay, so now as you all can see on the screen, this is in fact highlighted in blue, a notice of issuance of mandate. This notice was issued from the United States Court of Appeals for the Seventh Circuit, as you all can see at the top. The date this order was filed was, or the notice was filed was July 28th, 2023, as you all can see highlighted in blue. Okay, July 28th, 2023. So you all can see. Let's continue on. Also the date, upper left hand corner, July 28th, 2023. Again, Paul Hunter. Remember, I told you guys to remember that name. Why? Because he is the plaintiff, or should I say the appellant in this case. Okay? Against Jeff, who is the what? The appellees in this case. There's multiple ones that he sued, but I guess they just only put Jeff's name at the top. But let's continue. As you all can see, it states what? Herewith, the mandate of this court in this appeal, along with the bill of cause, if any, a certified copy of the opinion/order of the court and judgment, if any, and any direction as to cause shall constitute the mandate. Record on appeal status, red text, no record to be returned. So now let's go to the next page. Let's read the order. As you all can see, this document is titled Final Judgment. Okay, you all can see final judgment. This final judgment was issued in the Court of Appeals, the Seventh Circuit, the same court that he said that he lost in. Correct. But I just want to go over this order just to show you all why he lost and why everyone else is losing. Let's continue on. It states what? June 16, 2023. The official court seal on the right side, which says certified copy. So you all know this is a certified copy. Again, the plaintiff and the defendant is the same. And it states what? The judgment of the district court is affirmed in accordance with the decision of this court entered on this date, tax cost against the appellant. So again, the appeals court affirmed the district court ruling. So again, they dismissed this case that he brought against the defendants. So the defendants won, or the appellants or the appellees won, and the appellant lost. So because the appellant lost, the tax cost for this hearing is billed to the appellant, who is Paul Hunter, the individual on the video who claimed that he won in the Supreme Court. We're going to go over that too, just to further prove you all that that was a lie. But let's continue on. Okay. Let's read right here where it states order. It states, Paul Hunter seeks to overturn a Wisconsin state court order related to his unpaid child support. The district court dismissed the case for lack of subject matter jurisdiction, ruling that what? That the Rooker-Feldman doctrine bars his claim, right? His claims. Then it says what? We affirm. So the state court, so the Court of Appeals also affirmed the decision that was stated in the district court. Okay, but let's continue. So again, he lost the appeals. But let's continue on. It states, after Hunter failed to pay child support in the period of hearing, a Wisconsin state judge held him in contempt and issued a warrant for his arrest. The judge ruled that Hunter could purge the contempt order by paying $3,000 or by requesting a hearing to demonstrate his inability to pay. Hunter instead asked the court to dismiss the arrest warrant. The court's commissioner denied the request, and another judge scheduled a hearing for Hunter to appeal the commissioner's decision. But Hunter asked that the hearing be canceled, and the court removed the hearing from his calendar. So again, guys, so he had an opportunity in the state court to appeal that decision. But instead of doing that, he requested that the hearing be removed from the court's calendar. And then from there, he did what? Let's continue on. Hunter then brought this suit in federal court against Wisconsin state court judges, the state court commissioner, and others for failing to dismiss the warrant, citing various constitutional amendments, the 1st, 4th, 5th, 6th, 7th, 8th, and 14th, as well as several federal statutes, most notably 31 U.S.C. subsection 372 OD, which lays out the garnishment procedures for an agency collecting money owed to the United States. He claimed to be injured by the warrant and the garnishment of his unemployment benefits and tax refunds. The defendant, in return, what? Moved to dismiss the complaint based on the Rooker-Feldman doctrine, okay? So again, that's what the defendant automatically does. Like I was telling you guys, once you file your complaint, they're going to automatically motion to dismiss your complaint based on the Rooker-Feldman doctrine. Why? Because it prohibits cases brought by state court losers complaining of injuries caused by state court judgments. So again, guys, once you become a state court loser, and you probably go through the steps. They make an order against you, and then follow the proper state channels to overturn that order. But instead of doing that, the brother, he recanted his appeal in the state court and went straight to the federal court to try to file a lawsuit, which wasn't the smart move and wasn't the right move to make. But again, case law to support that. But let's continue. It states the district judge dismissed Hunter's constitutional claims without prejudice and his statutory claims with prejudice. Regarding the constitutional claims, the judge determined that these were barred under, again, the Rooker-Feldman, because Hunter sought to do what? That's why they dismissed the guys. So for all that's in the same situation, that's why I tell you all this. Start at federal district court unless you know what you're doing. And 9 times out of 10, those who filing don't have a clue what they're doing. They just being told what to do. Then it states. So this is why they dismissed it, because they claimed that Hunter, he sought to revise and undo actions taken by the state court. So again, once the state court enters order, and the state court has proper jurisdiction, and you properly showed up, and you argued your facts and stuff like that, you cannot now say, well, I'm going to the federal district court after the order's been entered in, trying to receive remedy or trying to use the federal district court as the court of appeals. That will not work. But let's continue. The claims were alternatively barred. The judge ruled under the domestic relations exception to federal jurisdiction, which blocks what? Federal adjudication of cases involving child custody decrees. So now, guys, in the last video I did pertaining to the attorney who filed his case pertaining to child custody, this is why it's going to be thrown out according to the Rooker-Feldman doctrine. So I'm just showing you all that it's the same thing in all these cases, because the individuals that's going and filing these federal lawsuits, they lack understanding of what they're doing, and they lose every time. But let's continue. And also, case law to support that. Then it states, as for Hunter statutory claims, the judge explained that Hunter could not state a claim under 31 U.S.C. subsection 372 OD because that statute is limited to federal debtors, and Hunter alleged that the IRS applied his benefits and refunds to his debt owed to Racine County. Nor could Hunter, the judge added, bring a civil suit under the many criminal statutes he listed in his complaint. Let's continue. Then it states, on appeal, Hunter argues generally that the district court misapplied the Rooker-Feldman doctrine, but the judge correctly ruled that the doctrine blocked Hunter's suit. Hunter expressly seeks to challenge the state court order authorizing his arrest and seeks an injunction against the contempt order, an endeavor squarely prohibited by the Rooker-Feldman. So again, case also support that. So because the grounds that he's seeking reversal, those grounds are barred by the Rooker-Feldman. That's basically what the judge is saying. But let's continue. Hunter also seeks to undo and prevent further garnishment of his unemployment benefits and tax refunds, which the IRS applied to his debt with the Racine County Child Support Agency. But the alleged garnishment injury is rooted in state court's determinations that he owed $3,000. See case law to support that. And only a Wisconsin appellate court or Supreme Court of the United States can overturn that judgment. Case law to support that. But let's continue. Then it states, Hunter also contests the application of Rooker-Feldman on grounds that he was never provided a hearing to challenge the state court judgment. But while Rooker-Feldman does not apply when state court rules or procedures deprive a plaintiff of a reasonable opportunity to raise his claim in state court, case law support that. So again, guys, the judge just gave you a reason on how to get past the Rooker-Feldman doctrine. And it simply states that what? State court rules or procedures deprives a plaintiff of reasonable opportunity to raise his claims in state court. So now, if you have a claim in state court that you was trying to actually file, but they barred you that opportunity to file those claims, then the Rooker-Feldman does not apply. But in this case, the Rooker-Feldman does apply. Why? Because he had the opportunity to have a hearing on the appeal, but he did what? He reconsidered that appeals mistakenly, and once he did that, he went to a federal district court. So now he automatically lost that opportunity to bring it because he should have carried out his appeals in the lower court. Maybe the lower court would have reversed it. But let's continue. Then it states, Hunter has not identified any such obstacles. Indeed, to the extent indigency was as a hindrance, Hunter was informed in the order authorizing his arrest that he could purge the contempt order by seeking a hearing to show his inability to pay. But rather than pursue that option, Hunter asked the court to remove a hearing from its calendar. So again, the same thing I was stating, guys. So because he requested to remove the hearing from the calendar, he actually had the opportunity. So once he waived that opportunity, then that's his fault. That's it. But let's continue. Then it states, A final note regarding the disposition. Although we affirm the judgment dismissing this case, we modify it to be without prejudice to Hunter's statutory claims, insofar as he complains of injuries that are inseparable from the state court's judgment. Dismissal for lack of jurisdiction under the Rooker-Feldman must be without prejudice. So it's basically saying that they're going to amend the order because the dismissal shouldn't be with prejudice, it should be without prejudice based on the Rooker-Feldman doctrine. But let's continue. Then it states, and at least one of Hunter's statutory claims purportedly brought under 301 U.S.C. subsection 372 OD appears to allege the same injury as his constitutional claims about garnishments that the district court lacks jurisdiction to address. To the extent Hunter alleges injuries independent of the state court's order, apparently including his claims that asserts improperly in a civil suit that defendants violated criminal statutes. We affirm the judgment dismissing those claims with prejudice. So they dismissed those claims with prejudice. Why? Because they could have made a ruling on those claims. Then it states below, we affirm the judgment as modified. So the order was dismissed, meaning his petition was dismissed. So the defendant won in this case again, as I've been telling you guys. But let's continue. Let's see what else is on here. Let's see. Again, that's just letting you know. Order, upon consideration of plaintiff's motion for finding of facts and conclusions of law filed on July 14, 2023, and construed as a petition for panel rehearing, all members of the original panel have voted to deny the petition. Accordingly, the petition for rehearing is denied. So even when he filed a petition for rehearing after that, they also denied that as well. Okay, but let's continue. Okay, that's it. So that's the only order that we have. So now that we went over that, let's go back over his recording because I want to hear him again. And I want you all to hear him again say that he got victory in the U.S. Supreme Court before I put the Supreme Court order up to show that he's a bald-faced liar, okay? So, again, he said that once the 9 justices go, and once you have your hearing before the 9 justices, which he never had a hearing, but he claimed that he had one before the 9 justices, and after the 9 justices made a ruling on his case, you cannot find it because they don't want us to see what happened in his case in order for us to use it. So as you all can see, that was also a lie because I just showed you guys his entire case. I showed you the order that he lost in the Court of Appeals. So now let's hear him say that one more time. And then after that, we're going to go to his United States Supreme Court ruling. Let's go there.
All child support is a Ponzi scheme.
Was you on child support?
I was on child support, and I took my case to district. I took my case to appeals, and I also took my case to the United States Supreme Court, which is the highest court. And my case was dismissed. And anytime you take your case to the 9 justices, they're going to make sure that your case disappeared because they don't want anybody to get a blueprint of how you did this. All child support is a Ponzi scheme.
Okay, so again, we heard it for the 3rd time. Like the Bible says, out of the mouth of 2 or 3 witnesses, let each matter be established. So we heard him 3 times say the same thing, guys. That what? That he received remedy in the Supreme Court by the 9 justices. And once he won, you cannot find his case because they don't want us to see what transpired in it, which is a bald-faced lie. So now, let's go to the Supreme Court order. Let's go there. Okay, so now as you all can see, this is in fact his Supreme Court order of the United States, highlighted in blue, that he claimed that we could not find. Why? Because they supposed to somehow got rid of the case and he magically won, which is all a bald-faced lie, guys. Like I tell you all, the truth is going to be the truth no matter what. Once you get out of your emotions and see what's really going on, then you can properly defend yourself to get the remedy that you all are looking for. So now and again, highlighted in blue, it states what? Supreme Court of the United States. Let's continue on. And where? In Washington, D.C., guys. But let's continue on. It states what? Clerk, United States Court of Appeals for the 7th Circuit. Right? But let's continue on. Let's keep reading. Again, Paul Hunter, as you all can see. Then it states what? Dear Clerk, the court today entered the following order in the above entitled case. The motion to direct the clerk to file a petition for writ of certiorari out of time is denied. Okay, so what happened was he filed his writ of certiorari late. And because he filed it late and not in time, the U.S. Supreme Court simply denied his petition. That's it. That's all, guys. He didn't win anything. Okay, he simply lost. So he lost in the district court. He lost in the Court of Appeals. And the writ of certiorari that he filed in the Supreme Court was denied. So he never stepped foot in the Supreme Court. So the Supreme Court did not rule in his favor. Everything was denied, as you all can see. So again, guys, I'm letting you all know now. I will be the only person that you all know that we're going to win in the United States Supreme Court. Okay? I'm going to show you all that it can be done. Mark my words, guys. I'm the only one that's going to show you all. Why? Because that's the proper court to file your claim. If you're not in the United States Supreme Court, I'm giving people the answer now. If you're not in the United States Supreme Court and you're filing in these lower U.S. district courts, you will lose automatically, okay? But look, that's what I'm going to do for today. If you all need my help, hit me up at my email at y'allismagnified@gmail.com. Again, guys, understand what you all are up against. You're up against the system who's trying to rob you, and you're also up against these so-called gurus on the internet platforms who's also trying to get over on you guys and scam you as well. So again, if you all need my help, hit me up at my email at y'allismagnified@gmail.com. Also, guys, it's not just him, it's many more. It's many more people out here putting out that false information, and I'm gonna get to them as well. Again, guys, I would like to thank you all for watching. Again, hit that like, share, subscribe button, and I say shalom.